Legal issue that I wish you saw. Your Honor, Mr. Know-It-All. Clear your eyes and I'll show you, 'cause with this writ I'll share. With this writ I'll share your lousy view. Yeah. With this writ I'll share your lousy view. Publish me up some new case law. Young appellate justice gonna make the call. Falling all over myself to argue perfect points in public policy, 'cause with this writ I'll share your lousy.
Good morning, everyone. That wonderful song was somewhat my doing and somewhat Timmy D. You can probably guess what Timmy D did and what I contributed. This morning's topic is a very interesting one. It's one we get questions a lot about. It's one that we constantly have questions from our clients about. So you went to trial and got this nice big verdict or small verdict or any type of verdict, or hey, we got this great settlement or we're about to settle. Now what? We have a fantastic panel today. We have an actual auction winner. We had an auction to get on the podcast. So why don't you introduce yourself first? To my right, Mike.
Mike Z, Ringler of Z Settlements, located in Costa Mesa, broker owner.
Awesome. And do you have any social media tags you want to get out there for the listeners?
ZSettlements.com.
Perfect.
ZEA? Or just Z? Z.
Yes.
Like this is Z
Like
Settlement.
New Zealand, but Z Settlements.
Z.
Tracy?
Hi, Tracy Cass with Cass Consulting. I've been doing this for 16 years and in pretty much all of California, loving what I do. Thank you so much for having me today.
And any social media tags you want to get out there for our listeners so they can find you quickly?
Hashtag Tracy Cass, hashtag Certified Financial Transitionist.
Fantastic. To my left, we have two actual attorneys here that are going to help guide us through the process of post-trial issues, because we have our settlement structure people to my right that's going to go over, we settled, what are we going to do? Jenny, introduce yourself, please.
Hi, I'm Bob Simon. I'm the boss.
That's exactly what it sounds like. And
That was really, you're not really going to introduce yourself?
He already said Jenny.
Oh, okay.
So I'm Jenny, by the way. Jenny Anglin.
My turn?
Yeah,
Brandon Simon.
we're looking at
Hi, Brandon Simon. How are you?
I'm doing great, thank you. And back to our left today, we have our special bartender that made us up something that's going to both get us drunk and keep us awake. Murat, why don't you introduce yourself and kind of what you mixed up for us this morning?
And who you are.
Okay, I'm Murata Behan. They found me on ZipRecruiter through a bartender search. Thank you very much for allowing me to be here today with you guys. And today's drink of choice is going to be the espresso martini. And I'll just give you a little backstory on that. It was created by a gentleman by the name of Dick Bradsell in London in the 1980s.
Is that a real name?
This is a real name. I verified it through 3 internet sources. So Dick Bradsell in London in the 1980s, a woman walks into the bar and says to the guy, I'd like a drink that will wake me up, then mess me up. And then he took a moment and said, I think I've got something for you. And the espresso martini was created in London in the 1980s. So cheers and enjoy.
Love it.
Thank you. And I think I'm the only one that has a drink, so Murat,
Yes.
if you could slowly pass those out, because these are excellent. These replace the vodka Red Bull that Jenny was drinking in the 1990s.
Last week.
All right, so we have a verdict. Brandon, you worked the case up. You passed it off to your brother, our brother, I guess. He got this nice big verdict. You have this great piece of paper. What do we do now?
You take the money and you move to Costa Rica.
I've known people that tried that.
No, you. The first order of business is obviously you have to get the judgment entered before you can really collect. You have to get the judgment entered by the judge. So usually meet and confer with defense counsel, put together a proposed judgment of some sort. And
Wait, what's the judgment, though? Didn't the jury already come
so
to?
the jury comes to an award. They tell you what the award is, you know, your past economic damages, future economic damages, pain and suffering. And then you actually have to get that award and get it entered as a judgment in order to collect on it. So what you need to do is you need to, it's very simple, you type up a proposed judgment, and it's basically the verdict form. And a jury of 12 was impaneled, and this is what they came to. And you submit it to the court, and they enter it. And once that happens, the clock starts ticking on certain things. But yeah, that's the first order of business. Make sure you get the judgment entered as soon as possible, because technically they're not on the hook. They don't have to pay anything until there's an actual judgment entered. Before that, it's just there's an award. Good, you got an award. Now you have to collect on it.
Well, Jenny's being beckoned, but I was going to ask her a question, but now she has a super dangerous martini glass being handed to her.
Here, I could take it. You could ask a question to her.
Maybe you ask, and if I don't want to answer, I'll just take a sip.
Wow, dangerous game. So, Jenny, how many times has the jury come down with an award, and then the defense said, "Here you go. Here's a check for the full amount"?
About never, I would say.
Yeah.
There's always a back and forth there.
And how many verdicts on cases that you have are unpaid right now?
There's at least 2 big ones that I can think of that keep me up at night sometimes. Not really.
You have 2 big ones that keep you up at night?
She has twins.
I have 2 hands. That's all I can handle. But yeah, there's a couple right now. I mean, more for the firm, but at least 2 that I have my eyes on right now that are still out there.
Yeah, I have 2. One's on appeal, so that doesn't count. But the other one, yeah. they haven't
And
paid
what
yet.
we get a lot of questions about a high-low agreement. When do you do them? What process does it do? Brandon, what is a high-low agreement, and when does that conversation start happening?
So, very basic terms, a high-low agreement is an agreement. Usually, it's a way for the insurance company to mitigate their risk. So, there's a low bracket and a low end and a high end. Take for instance $100,000 to $500,000. So that means if the verdict comes in below $100,000, you're guaranteed at least $100,000. But if it comes in above $500,000, you can only get $500,000. And usually, anywhere in between, you can collect anywhere in between. But usually with that comes an agreement of paid within a certain amount of time, which is great. You don't have to deal with appeals or new trial motions. You don't have to worry about collecting on your judgment. And also with that, there is a no appeal agreement. So you can make sure it works for the insurance company because they're ensuring that, hey, they don't get tagged for $1 million. But it also is beneficial to your client because you get paid quick. You don't have to worry about an appeal, and you have a floor that they'll be able to recover a certain amount no matter what, and they'll be able to cover.
Mike or Tracy, have either of you ever participated during a trial when kind of guiding the plaintiff if they get to this number, or has that ever happened where you're actively either sitting in on a trial or you're helping the client guide their decision during that process?
Often, and I was just going to point out that in this high-lows, it's also a good idea to get some language in the agreement that the defendants will cooperate on such paperwork that's necessary. Otherwise, you run into constructive receipt issues. So it's good to have that ability to structure if the client so chooses, and then it's up to Tracy or I to convince them that this is a good part of your investment bucket with your settlement proceeds.
So there's a lot of listeners out here that don't know the legal jargon, and when we say structure, what just generally, Mike, what does structure mean?
Structure's anything other
pretend
than...
you're talking to Murat, who doesn't know anything about anything.
Well, we know that already,
he's a
but you make a
CFO.
great drink, by the way. This is excellent.
He's well versed in 1800 London.
Yes,
archaic.
that's the only thing I know about is 1980s bar culture. So please,
Good stuff.
explain
Good stuff.
settlements to me.
Structure settlements, anything other than a lump sum distribution. So we have the ability, Tracy and I, to do periodic payments, benefits to protect these really unique investors. This is a one-time event. You don't want them to have to go through what they went through to get to this point. It gives them the ability to structure benefits to address needs going forward, which is key. That's important because interest rates don't carry the day. It's an annuity product, which is what we do in the way of structuring benefits. And loss of earnings, future medical needs, that's what we do.
So you mean after the verdict, the injured person can't come back 20 years later and say, I need money for this back surgery?
You got one chance, and this is it. So you want to do it right.
And Tracy, have you ever participated during the trial process to help guide somebody?
Absolutely. One of the hardest things for the plaintiffs to really think through is, what is a good number? Is it $1 million, and what does that actually mean in day-to-day life? So when you break it down to say that $1 million, even with your net number, this will take care of your debts. This will give you your immediate needs. This will also give you guaranteed income for the rest of your life. And sometimes we're fortunate enough to have enough to continue to take care of their income forever, as well as taking care of their medical needs and making sure they have the proper insurance.
Yeah, I know we had a trial. I think it was, my son's 6, and he was born during that trial. So Rob Gibson came in on it and with my brother, and we had him set up a structured settlement when he got time to get paid after the appeal was denied. And I know that he set aside a certain amount per month, where I talk to him to this day, and he has a house free and clear. Mm-hmm. He's got money coming in every month that pays all of his bills. So he doesn't have to work, and he's comfortable, and he's got money set aside for his future back surgeries. And then we've had clients. Jenny, have you ever had a client that just came back 2 years later and just blew through their money?
Luckily,
2 months later.
Yeah.
2 weeks later.
2 weeks later.
Yeah.
I haven't, but I know others who have, and it's just really sad because you try so hard to tell them up front and educate them on the right way to do it, but you can only do so much. And that's why it's really great when you work with somebody like Tracy, who gets involved early on with the client and builds trust with them, because then, it's like they just feel like, even if they don't want to listen to me, like Tracy's there, and it's just extra people that they can bounce their ideas off of.
And one of the biggest points that I really want to get across today, both Mike and Mike had mentioned the word constructive receipt.
Yeah, I didn't know what that meant. I wanted to pretend like I knew and just let it go.
Go ahead, Mike.
Don't laugh, Marat. Constructive
receipt. Once you as counsel or your client has the money in hand, yeah, I can do an annuity. I can do, simple single premium immediate annuity, but you lose the tax benefits of what we offer. The tax-free benefits is one of the few things there's bipartisan support for in Congress for this product, because it protects people who have been physically injured. So you want to make sure that they don't have a receipt or constructive receipt through their counsel, so they can do our product, and that's key to what we do.
So no, it cannot come to your attorney trust account and then go back out to purchase an annuity later.
You mentioned a tax benefit. What is the tax benefit to doing this type of process, Mike?
Well, it's a product that, because of the physical injury, Section 104A of the Internal Revenue Code says that compensation received through a personal injury settlement is not taxable, and you protect that ability through a structured settlement by executing the proper documents, which is why it's important to have that agreement and that high low that the parties will cooperate on such documents as are necessary. And then you can do, the rate of return interest rates right now are terrible. With the tax-free benefit, you add about maybe 2.5% to that real yield, and you've got a product that's tax-free, guaranteed. It's going to be there no matter what. It's a good product.
And there are no fees or costs for the client or the plaintiff attorney to set it up.
They're paid for by the life company.
That's amazing, and that's why we try to push this on not push it, but recommend, because we can't give financial advice to the client. We need to make sure someone that knows what they're doing says, hey. Now, Jenny, speaking of like tax benefits, have you ever had a client that is heading towards trial and has a very high loss of earnings claim, and there's a settlement potential versus trial exposure, and kind of what's the difference between settlement with that scenario versus going towards a verdict?
Yeah, definitely. That actually happens quite a bit. And I think that if you have a client that's sort of torn between settlement or trial, that's a very important thing to point out to them, is that if we settle your case, there's not going to be an allocation in the settlement agreement as to what portion of that settlement is for your lost earnings. Whereas if we go to trial and get a verdict, you're going to have, on the verdict form, all the different breakdowns. And if it's, $800,000 or $1 million future loss of earnings, then, you're creating an issue where you're going to potentially have tax that you're going to owe on that, because it's replacing income. So I always explain that.
But Brandon, is the rest of the things on the verdict form taxable or not taxable?
No, only the loss of earnings is taxable. So that's why if you do, like Jenny said, the difference between settlement and verdict, even if you do get a verdict, I mean, how often are we're getting verdicts once a month? Probably at our firm.
We have four active trials right now.
But how often are those going to a collections phase, right? We almost always settle the verdict afterwards. And the reason we do that is because if you collect on an award, you collect on a judgment, and there's a loss of earnings on there, then you're dealing with taxable income. Mm-hmm. So usually it's in best interest for everybody is if you try to settle the verdict after. I mean, it sounds weird. You're settling a verdict.
It does. I mean, you have, let's go have the jury make a decision, and then you're almost negotiating the jury's decision. And Brandon, what are some of the factors that go in post-trial, some post-trial motions, some post-trial things that can happen that gain leverage for the plaintiff, lose leverage for the plaintiff, that makes it negotiable?
So there's the biggest thing is recoverable costs for us, for the plaintiff, and the biggest thing is the biggest tool that we use is the 998, and that comes into play after you get the verdict. If you get an award,
Jamie, what's a 998 for our non-legal listeners like Marat?
Civil Code of Procedure 998.
998. What the heck is that?
All right.
Is that a lotto number? Or?
It's like Blink 182 times 3.
Is it really?
998 is it's an offer to settle, and basically either side can do it, and usually both sides will do it at some point, sometimes many points throughout the litigation. It's an offer that has a penalty if you don't accept and you fail to beat the other side's offer. So if there's a 998 for $1 million that the plaintiff served, and the judge or the verdict comes in at $2 million, then that's great.
And then what's the penalty for the defendant on that?
Well, if the defendant served a 998, and you as the plaintiff failed to do better than that 998, then you're going to be hit with them coming for you afterwards for their expert costs.
Yeah, because normally in California, everyone bears their own attorney's fees and costs, and this is kind of a cost-shifting provision in the California Code of Civil Procedure 998 that says, hey, you didn't take this offer, we wasted our time with this trial, you're going to pay for it. But then there's this added benefit for a plaintiff, Brandon.
Yeah.
Which is?
So if you beat your 998, you get post-judgment or pre-judgment interest from the date the 998 was served. So a lot of times at our firm, we'll serve a 998 as soon as we file. So in LA, sometimes you're getting trials 3 years after you file, and you get interest from the date of the filing or the date that 998 is served, which could be 3 years, 4 years, even 5 years.
We had a trial finalized last week.
Yeah.
That was a retrial.
6 years of prejudgment interest.
Yeah.
And you get interest on the verdict, not the 998 amount. So if you serve a 998 for $50,000, the verdict is $2 million, you get interest 10% on that $2 million, not the $50,000 per year.
So 10% of $2 million is, what's 10% of $2 million?
I didn't realize math was involved this morning.
You're the CFO. Come on.
I'm the CFO that uses his calculator.
The Texas Instruments?
TI-82 graphing calculator.
Wow.
Yes.
Do you have games on that?
Obviously.
No. So to answer your question that you asked earlier, so one of the tools that plaintiffs can use post-judgment, post-verdict is the memorandum of costs. Obviously, you can recover all. If you're the prevailing party, which is if you're the plaintiff and you win $1,
yeah,
you're the prevailing party. So you can get I forget what the code section is, but you can get regular witness deposition fees, service of process fees. But if you beat your 998, you also get interest and you get expert witness fees, which, if you're trying a products liability case or even a complicated spinal injury case, your expert fees can be well over $100,000. So that's a huge tool that you can use to leverage a settlement post-verdict. And usually what we do is we will present the opposing side before we file our memorandum of costs and say,
how long... you got the judgment entered.
Yeah.
How long do you have before this all starts?
So once the judgment once you get notice of the judgment being entered, so usually the clerk will serve notice. You get 15 days, not court days, just 15 calendar days to serve your memorandum of costs, and it's a very quick turnaround. So usually what we do is as soon as that verdict hits, we get our dad is the person in our firm who does it, but you should have somebody that knows.
That's pretty scary.
He's great. He's good. He's very good at basic math and keeping records. He's very good at it. He had, growing up, he had that firebox that kept everything safe. That was all like our birth certificates and stuff. So he's good at keeping records.
You know what was really in that firebox?
It's probably Playboys. Yeah. I don't know. I know exactly what was in that box.
We got that Burt Reynolds spread from 1987.
No, but so long. long answer short is use the memorandum of costs. You can leverage the costs, especially if you beat a 9-8, to leverage a settlement post-verdict so you don't have to deal with a taxable income situation. Prejudgment interest is huge. Make sure you include prejudgment interest on your memorandum of costs because there's some split authority on whether you need to do that or not.
But isn't that a moving target? Like, how do you put a finite number in the memo?
So this is a new hot topic can we get something on the bottom of the screen? It's a hot topic for post-production. But
Hot topic.
Murat's favorite store.
Obviously. Did you see those belts back in the day? The studded ones? They used to have a seatbelt belt. That is a fact.
Was it a GMC product?
It might have looked like the old school GMC belt. Yes, absolutely.
Now I lost my train of thought. Great. I literally forgot what I was talking
I
about.
have no idea where you were going with that.
Hot topic. Oh, so make sure Brad asked if the prejudgment interest is a moving target because the prejudgment interest accrues up until the judgment is satisfied. So how do you put that on your memorandum of costs? We usually calculate it from what it is on that day of filing, and then we put something in the worksheet that says, the code section CCP 3291. It accrues 10% per year until judgment's paid. So just make sure you have some sort of reference to prejudgment interest on that memorandum of costs because there is some authority out there that says
because they have that judicial council form.
Yeah.
Where do you put that?
So I think the new judicial council form, there's number 16. It's just other. Just put it in other. Just as long as you throw something in there that references prejudgment interest, you cover your ass because it's mandatory. But there is some authority that says if you don't claim it, you could waive it. But it is just reference it some way or another.
What about new trial motions on either side? What's an additor? What's a remitter? Jenny, do you know the difference?
Brandon. Okay, so I think you're in a better position to talk about the new trial motions.
Yeah,
you've handled more of those.
You know what an additor and remitter is.
Yeah, but I'm just saying. So additor is obviously if you think that somehow they messed up and you want to go and talk, you want to like put something in front of the judge to try to get something like maybe it's usually like medical. Well, it could be anything, but medical specials or pain and suffering, something like that. And you want the judge to basically tack on some extra money for you. But the new trial motion, I think it's all in your wheelhouse.
Can I ask a question? You mentioned the medical component. What do you do for future medical relating to Medicare recipients? Liability MSAs.
Well, we can't, like, as far as the trial is involved, we can't really talk about that.
Sure.
For anyone listening out there for a civil trial, right, Brandon, you can't talk about insurance. You can't talk about this person has Medicare. But behind the scenes, this person is eligible for Medicare. And I think, Mike and Tracy, you're probably in a better position to talk about what is a Medicare set-aside? When do we need to do that? That's a really big topic, and I have no idea. I usually just forward it to someone in your profession and say, just figure this out for me.
Well, there's a statute that's been on the books since 1980, the Medicare Secondary Payer Statute, that, pertains to all of us here that at some point will be Medicare recipients. That Medicare, for many, many years, was just sort of ignored. And the issue being now that with a Medicare budget, we want to protect the general fund. Everyone owes a duty, an obligation to Medicare to protect Medicare's interest. And so what that means is for those Medicare beneficiaries that have an ongoing exposure for future Medicare-type covered expenses, everybody has to be aware of what that exposure is and in good faith try and make a determination of what that value is going forward. You want to add that, Trace?
Yeah. Probably the easiest way to think it through is if somebody is on Medicare or within 2.5 years of being on Medicare.
And when does that usually happen? Is it an age? Is it there's disability? When is that? How do you know?
You will know if they have end-stage renal failure or if they're close to 65 years old, or it actually doesn't matter even if you have a 25-year-old who has a work history. When they apply for Social Security disability, once they get approved, and they have to wait until 6 months after the incident to apply, after they receive confirmation that they are Social Security disability eligible, 2 years later, you'll automatically get the Medicare card. So that's your 2.5 years. So, and they're also pretty strict on the fact of if your client is intending to get on Medicare too. often I'll find attorneys that'll say, don't call them, and because we want to get through it. However, right when it gets done, they go and apply. What I think a lot of people don't understand is that the defendant has a obligation to report the settlement to Medicare. They also have an obligation to report the ICD-10 codes.
The what?
ICD-10, the billing codes. Okay. Super fun. And so what happens is when the client then in the future, say even a year later when they go for that particular surgery and the doctor sends in the code for billing, it's going to get rejected. The provider's going to call the client and say, we've rejected because we have notification that there was a settlement at one point in time. Who is the client going to call when they get that rejection?
Us and then you.
Yeah, exactly. So that's why we cover ourselves up front. There is no law that says you have to do a Medicare set aside. The other way to really think it through is it's a future conditional payment letter. We're all familiar with the conditional payment. Really, a Medicare set aside is a future conditional payment. Does the client treat or not? We don't know. But if we don't encourage them to pay attention or at least set it aside, that's where it can come back to bite.
And it's really a matter of good faith. I did a presentation for the regional director and his team up in San Francisco for Medicare and Medicaid. And the bottom line is it's about good faith. As long as the parties recognize that there's a continuing exposure for medical care that Medicare would otherwise cover. Coverage A, hospitalizations. Coverage B, doctor visits, lab tests, durable medical equipment, things like that. As long as that's been contemplated in the settlement, they're good with that. You don't have to submit it to Medicare for approval, and that's always been a big contention. How do you do that in civil cases? It's as opposed to workers' comp. A lot easier in work comp. It's been, kind of the law of the land since 2001, but it's becoming an issue. It'll be more of an issue perhaps as early as September of this year when Medicare issues some guidelines on how we treat liability MSAs. But it's good faith. What kind of future medical needs does my client have, does your client have, going forward that Medicare would cover, and just set that aside.
Where does it get set aside to? Like, where does it go? Does it go into the ether? Is it put into an account?
The cloud.
Cloud.
Everything goes in the cloud.
Everything.
Yeah. It's a fund that they can control. They can have it professionally administered by a vendor that is responsible and can negotiate better prices. I always recommend on work comp cases that I settle, if you have an opportunity to have it professionally administered, do it. It takes a big monkey off your back. They're going to make sure that you're billed appropriately. If you or I go to the doctor, that office visit is going to be $150, whereas Medicare may only, ding the Medicare set aside $50. So it's a way to not artificially spend down the Medicare allocation. It's a way to reduce the value because you're using Medicare rates, not what we'll pay by way of cash.
And what happens, if that person passes away and they've got this Medicare set aside for future medical treatment, and where does it go? Is there a beneficiary? What happens with that?
Well, 6 months after the death of that individual, any unused that haven't been processed and being have a conditional payment lien asserted by Medicare, it's released to the estate. So it's money available to address the Medicare type covered needs, protects the Medicare general fund. And that's kind of the law of the land.
Medicare is just making sure that you're not taking the money, buying a Winnebago, driving across the country.
That's what you would do with your money, Chase? I'm going to buy a Winnebago.
An RV, a really nice RV.
I got to talk to Steve.
Yeah.
So they just want you to, take them into consideration that you're not blowing the money and then pushing the bill back on them when you've been compensated for it during the settlement.
I mean, that makes sense because there may become a scenario because I see some of these politicians trying to enter the race saying Medicare for all. And if that happened, how would that affect your profession? Would every single settlement have to be Medicare be contemplated and allocated for?
Yes.
Yes, absolutely.
Voters out there, take that into consideration.
Exactly.
We'll go back to the attorneys over here now that we learned a little bit more about Medicare set aside. So we went over kind of what an editor and remitter is. So let's say, how long does someone have to file an appeal, Brandon? What's that process look like?
An appeal?
So you got a verdict. The defense thinks this is excessive.
I think you have to give notice within 60 days of the judgment being entered. Is that accurate?
There's I think there's extra 10 days if you file a new trial motion.
Right. So so first, usually there's a new trial motion, and that's a very quick turnaround. So I think for new trial motions, and usually you can tell if there's going to be one filed, but for new trial motions, I think you have to give notice, not necessarily your motion, but you have to give notice of an intent to move for a new trial. I want to say within 15 days of the judgment being entered. So that
Notice of entry of judgment.
Notice of entry of judgment. And then that notice itself, it has to be pretty inclusive of what grounds you're going to move for. You can't. So if you're going to argue juror misconduct, it needs to be in there. If you're going to argue attorney misconduct, it needs to be in there. If it's not, we had a scenario where the defense did not list juror misconduct, and they weren't allowed to bring that in their memorandum of performance and authorities when they actually moved for a new trial, because the turnaround for the actual motion and the opposition for a new trial motion is very, very quick. And usually when you're dealing with new trial motions, you have to get juror declarations. And if you get a notice that says we're not going to argue juror misconduct, usually the other side's going to say, well, I don't need to talk to the jury. And then they get a motion that does say juror misconduct, and they say, well, I would have talked to the jury and got declarations and got a relationship with them if I had known you were moving for that. So that's the basis behind that. But general rule of thumb, after a verdict, you should always just talk to your jury in the hallway, get a sense of why they ruled the way they did, good or bad, and build a relationship with them. Talk to them on email. Once the verdict's over, it's fair game. You can talk to the jurors, talk about why they ruled the way they did. And if they got a good verdict, and jurors usually are pretty proud and of what they did, and they sacrificed their time away from their family and work to be on a jury. So you usually say, hey, this other side's trying to take the verdict away from you guys. You worked your butt off to get there. You can talk once
it's open. It's open. You can talk to them after the verdict. I remember after one of our early verdicts with Brian Panish, we got across from the LA courthouse. We had Brian told all the jurors, let's go over. We're going to have lunch across the street. And every single juror showed up, and we had lunch and talked about the case. And then sure enough, in the defendant's motion for a new trial, they were saying they tainted the jury by taking them out to lunch. And the judge said, so what? You're allowed to. You can marry each and every one of them. It doesn't matter.
Only in Utah.
Yeah, we've had jurors that I think a verdict that Bob and I did in Riverside, and one of them is a psychiatrist now, and we've had sent clients to her before. Now after the verdict, I mean, once the verdict's over, it's fair game. They're regular people. You can talk to them. You can build it, but it's always important to talk to your jury and be prepared to address new trial stuff with them. Say, hey, they're saying you thought about. You considered.
So I know you've been talking for a while, but I'm going to ask you a question that I know you know a lot about. Is what can you put into a juror's declaration? That's
I thought you were going to say video games. Finally,
Mario Brothers.
It's Mario Brothers. I know that New Jersey Mario.
My apologies.
Okay, sorry.
So what do you put into a juror declaration? Like, what can jurors talk about?
Good question. I've seen jury declarations mostly from the other side, not to pick on them. But to pick on them, you have to, when you do juror declarations, there's specific case law that says you have to put in there very specific things. It has to be open and observable conduct. Jury declarations that say, I ruled this way because XYZ, or the jury ruled this way because is not admissible. You have to say the jury openly discussed this. The jury openly agreed to decide because of this.
It's like the opposite of the hearsay rule.
Yeah. You don't want internal, my thoughts or what the jury just did, conclusory statement. You have to actually say, this is what they said. This is why we all openly, and that's a big, openly agreed and discussed, and this is why we all came to that decision. So, yeah.
So let's go back. We usually I think every podcast we've done kind of a little fun game. It's Family Feud style, where we have two teams and I ask a question and we see if you can get them all right. And I didn't poll anybody. I just, in my brain, this is what I came up with, and it could be completely wrong, but this is what I think.
Show me living room.
Ding!
Murat's been waiting. Murat has a funny story about Family Feud and living room.
That's true. So I've been watching Family Feud for years and years and years, and I've never seen the term living room as an answer. It's such a common term. It could be an answer at any moment. But 15 years, whatever, never seen living room as a Family Feud answer. Fact.
So he's waiting.
Just waiting.
So as soon as it's the topic, living room, and he's been waiting for years.
So hopefully today is the day in this podcast.
You know, my top 5 rooms in your house. I mean, that's what it is.
Kitchen. No, it's a basement.
All right, so
And when that
today's-
comes up, you're gonna flub it. You're not gonna say living room. You're gonna get.
Yeah.
all right, today's Brandon. We've got like 10
Okay.
minutes
Okay.
here, man.
Sorry.
We're gonna go guys against the girls. We're gonna go Mike and Brandon, Jenny and Tracy, and the question. We have the top 5, maybe 6 things on the board for top 5 reasons for your client to structure their money.
Ladies first.
Start thinking. We got the 5, maybe 6. I think 2 could be the same one. You can chime in, Jen. If you want to get it wrong, just open your mouth and talk.
okay, so this is hard because I don't want to. I think you should answer. You're the expert, but I would say to protect their. This is gonna be. It's gonna be on there somewhere, but to protect their government.
Wow, number 1.
Yes.
Keep government benefits. Number 1. Can I get a ding, Timmy? There we go.
Right.
Good point.
And Mike, what does that mean? Why would you protect? How does that come into play? Why do we do that? Or why do you do that? I don't do it. Why do you do it?
Well, say you have a client whose child is disabled, cerebral palsy. We'll use that as an example. A child has Medi-Cal benefits, and there's a trickle-down effect for the parent to that child with an award. So you want to make sure you protect the public benefits for that child, or your client who is disabled and receiving SSI benefits, Medi-Cal benefits. That's important. Simply because, with Medi-Cal comes, in-home support services, if you have someone that needs attendant care. So protecting public benefits is really important.
And Tracy, what happens if someone that has like Medi-Cal gets this big lump sum? What happens?
You're kind of sorting through the differences between needs-based Medi-Cal and regular Medi-Cal.
Special needs trust as a whole, it's a big topic. It's not a huge topic, but I do want to get to it. We're going to do this game. We're going to talk about special needs trust. So start thinking about, because I don't really know what it is. I push it off to you guys. But the girls are still on the board.
Living room.
Living room does not appear.
A modified living room to accommodate a wheelchair.
Outdoor living room?
Living space.
It's all about open floor plans right now. Okay, Tracy, Jenny, you still have 4, maybe 5-ish things on the board.
Tax-free. Income tax-free.
Ooh, number 5, tax issues. And what do you need to be concerned about with tax issues?
Making sure that during the settlement process, a structured settlement annuity is all income tax-free. So that's why we have to avoid that constructive receipt that we talked about earlier.
All right, girls want to keep going? You want to pass and see if they fail? What do you think? There's 3 left. How do you want to do it?
Let's pass.
Okay.
Pass. Wow, pressure's on. Mike, Brandon.
Client's bad with their money.
Number 3 on the board. Not good with. I think you read this.
No. No. I play a very honorable game.
Clients just aren't good with their money. Mike, why would it? How would you identify that?
I had a gentleman a couple of years ago, 10 years ago-ish, who wanted to take his full settlement as cash. His net after attorney fees cost was going to be about $800,000. And he said, I want to take cash. And I said, it's your money, but why would you want to do that? Because my brother's a day trader. He's done really good. I said, ask your brother about dollar cost average
This
investing.
is going to have a happy ending. Right, Murat? You know all
He
about those.
goes, what's dollar cost average investing? I go, ask your brother. He comes back and says, my brother thinks it's a good idea. So we did a good lump sum at the time of settlement. We did a monthly income for 10 years and a big lump sum at the end of that. 2009 happens, 2008, 9. He came back to me in 2009 and said, Mike, I lost a little bit of money, but nothing like my brother did. I've got monthly benefits continuing. Hopefully the market comes back. I've got a big lump sum at the end of that. Mark, you're my poster child, because that's what this is about. It's about protecting people against well-meaning, but maybe not the best advice they're going to get from other people in the way of a spendthrift. It protects them. That's what our product's about.
And that's, it's not just conservative. It's almost guaranteed, right?
Absolutely guaranteed, and tax-free, because it's compensation of that physical injury he sustained. And if you ask any good financial planner, is an annuity a good part of my investment bucket, a part of? If they're being straight, they'll say yes. Well, what about if it's tax-free guaranteed? Absolutely, without question.
and talk about tax-free guaranteed. Well, this was another topic, but can attorneys structure their attorney's fees, Tracy?
Absolutely.
And what's the benefit of that?
Tax deferral.
And how does that process happen?
Wonderful. Same as the plaintiff, the information does need to be in the settlement agreement and release. It's custom designed, just like with the plaintiffs. So an attorney can start it. Usually we have two different directions, either very short term, just straight tax deferral, or sometimes an attorney will put it out for many years just to help supplemental income. It does need to be done during the settlement process, just as the plaintiff does. Attorneys look at it a couple different ways. Either they just are looking for short-term tax deferral, which means it can start in the next calendar year.
Like, hey, I'm having a giant year. I need to tuck $200,000 of this fee away for when? However long you want?
Actually, it's custom designed. So it can go out. Typically, it usually can start within a 20-year period. However, you can have it short-term, just 5-6 years, just to, a lot of times we say, especially with newer attorneys that are doing it for the first time, just to cover the overhead, to take the stress off. But if it's your more seasoned attorney, sometimes you'll have it for supplemental income or to build onto part of your retirement. So it can be short-term, long-term. Structured settlements can be done with cost of living increases, lump sums, and can be paid out.
I think it's a great idea.
Yeah.
I may or may not have done it 4 times with Tracy.
Yeah. And the neat thing is there are more
That
products.
sounded real bad.
That sounds so bad. Only 4?
I know.
You know my husband. It's
He was there. Mike, what were you going to say?
I'm not going down that. No, there are more products available now for attorneys to defer fees. More than just the standard structure, pushing it out for a period of time. There are programs where you can get some growth out of that money, depending on what the market is doing. There are programs with firms that we work with where you can, push it out and decide if you don't want that first payment when it comes due, you can push it to the end. So there's more flexibility now than ever before, and it's a good way to push off that tax liability.
Murat, what's in these martinis? Because I'm pretty toasty, and it's like 9:30.
It's the beans.
Non-alcoholic vodka, non-alcoholic Kahlua, decaffeinated espresso, and decaffeinated coffee beans.
Do you have any ideas back there for a structural settlement? Like, I just want to see what you're taking this all in. What are your thoughts?
It sounds like a great idea. I mean, honestly, if you want to have security for your future and a structure and kind of have like a, guaranteed money coming in, so you know how to budget on a monthly basis, on a yearly basis. I mean, this just seems like the way to go. Seems
You're
like
on
a
Jenny
no-brainer.
and I's team now for Family Feud.
Okay.
No, he's
next
the
thing,
guy.
Living room.
Show me 4 times with the husband in the living room.
All right, we've got 2 left, and I think like both of these 2 have been hit upon already with other discussions. I'm just going to talk about them because we've already talked about them. Number 2 is you have dependents, and we spoke about that when you wanted to talk about like keeping government benefits with dependents. Like, how does that come into the conversation when you have kids or you're taking care of somebody and you want to structure?
What if you want to do an education fund for your child on a tax-free basis?
That's great idea.
Or that young client, a minor. How many of us knew what we wanted at age 18? And so giving them that full access to those funds.
Mike, what did you want to be when you were 18?
Oh, my God.
We're going to go around the room.
A structure settlement consultant.
No. I was going to be a ski instructor. And that's why I took that money that Grandma and Grandpa gave me, and I didn't use it for what I think they wanted me to, but I had a great life experience.
Tracy, what did you want to be when you were 18?
Cosmetologist. Go figure.
Awesome. I wanted to be a comic book artist. I think I kind of still do, but Jenny?
I actually at 18 thought I would go to law school. So.
Well, boring.
I know.
Can we get the sound for the Family Feud?
Okay, I wanted to be a vet when I was a kid. Is that better?
No.
I loved animals. Oh,
You're 18. You're one of the. Wow. Very.
Yeah, I wanted to be an attorney.
Brandon?
I would have always, if I wouldn't be an attorney, I would love to be a college basketball coach. I love the process of like recruiting, and I watch games. I break down.
You're like a Bobby Knight coach, though.
Oh
right?
yeah, I would be out. I would definitely be ousted. I would throw a chair onto the court, or
our
choke
dad
a
was
kid.
our basketball coach,
Yeah.
and he would get thrown out every 3 games, guaranteed.
Yep.
Murat, how about you back there?
Podcast bartender.
Living the dream.
Dreams come true, baby. Dreams come true.
The next thing was just future medical care needs, and we already talked about that. Setting aside a lot of money or some money for either Medicare or you're going to have treatment.
Pay for your
Or-
insurance too, right?
Bam.
There you go.
I just did a case involving an individual where didn't want to settle. It was a work comp matter, and they just, you want control. You don't want to be in the work comp system. We can give you enough money to buy a medical policy, either through the Affordable Care Act or, there's a California high-risk medical insurance program for California residents. So it allowed her to move forward, settle her case, and buy a medical policy. So that's important.
All right, those are all, I think. Yeah, that's it. But we have special needs trust that we need to talk about because those are very important, and those kind of go hand in hand with the structured settlement sometimes, right, Tracy?
Absolutely.
And what is, Mike, will have you explain what it is first. What's special needs trust?
It's for special needs.
Wow. Nailed it. Giving the definition with the word you want to define.
Right. You've got an individual with special needs because they suffered catastrophic injuries, and that person is disabled. They're receiving Medi-Cal benefits. Anywhere else in the country, it's Medicaid, but in California, Medi-Cal, you want to protect those benefits because they have value. They extend the value of your settlement by being able to protect that ability for them to continue to receive those benefits. And it's the whole purpose of a special needs trust is to enhance the quality of life of an individual with special needs.
And Tracy, how often do you interplay a special needs trust with a structured settlement?
Very often. What happens is that the big thing to know is that if somebody receives more than $2,000, if you're a single person, or $3,000 as an individual, and they're receiving needs-based benefits, we need to pay attention. If it's a sizable settlement, by putting the funds in a special needs trust along with a structured settlement, it actually gives them both the benefits for the insurance and guaranteed income. By many times, the clients that we're working with have never had this amount of money. So creating an income stream so that they know that they have the safety and security, knowing that it's going to be potentially lifetime income and that they can spend up to a certain amount each month for the rest of their life and actually be okay.
So this sounds like it could take a long time to put together. So Jenny, when do you start bringing Tracy or Mike into the conversation in a case?
Actually, I try to get them involved as early as possible. If I anticipate that this is a case that would need a structure of any kind or special needs trust, I try to get them involved, way before mediation so that the client is comfortable.
You ever have either of them at mediation?
Absolutely. They're a huge help at
And
mediation.
a carpool buddy, right?
Yeah, it's always nice to ride with a structured settlement person, but no, I mean it's so much better. Like I said, the trust is key. The client has to not feel like they're settling their case and being bombarded by all this financial information and decisions that are really difficult for people. So the sooner you do it, the better for the client.
I agree. Giving an individual that feeling that they've got some control of this, of something they've got no control of the legal system, of what the doctors are going to say about their situation. It's just the personal integrity that you give these individuals, and the sooner you can get us involved, the more we can educate them about the process and options that they have, so that at the end of the day they're going to have a series of choices to make, and they're all going to be good, but we want to make sure that they have the best opportunity to make that decision.
All right, so we're going to be wrapping up soon, and the last thing I'm going to talk about is horror stories from when you gave someone advice and they either didn't listen or did listen and then didn't listen. So we'll start with Brandon. Any clients that you said, hey, buddy, you should talk to these people, and then they just didn't?
I think it was the first big, I wasn't even an attorney yet. It was just when we opened the office. It was that big wrongful death verdict we had. And it was the mother and the father were the
oh yes,
were the they're the ones who got the big amounts, and the mother was very smart, structured it, used it as a source to grow her business, and is doing very well and thriving. And the father
took a lump sum,
tried to build a house from scratch, from the ground up.
I know that I keep in contact with them, and I know the mother bought like 2 duplexes, and some of her daughters lived in one and managed it, and had everything structured, and the dad was coming back 6 months later.
Yeah. You don't know the value of money, how quickly it can go if you don't take care of it. So.
How about Mike? Any people you gave advice and they just they didn't listen to you?
Tracy and I have talked about this over martinis. We've got
We're having martinis,
Yeah.
so many stories.
Yeah.
You know, the one that comes to mind was a UCI student that suffered a TBI, and you look at her, talk to her, she was normal. She took a big lump sum against the suggestion of her lawyer. She took cash. She had a great 2.5 years, but she showed up at her lawyer's office. I've gone through that money, $2.5 million. What do I do now? And he said, I can't help you. So people don't understand that as unique investors, this is a one-time opportunity. You want to do it right.
Yeah, these are like NFL running backs. They got 3 good years, right, Murat? They got to put that money somewhere because they're probably not working again.
Yeah, unless your name is Frank Gore.
Frankly.
The hardest cases can be the slight TBI cases. Those are the ones that are sometimes
TBI is what?
Traumatic brain
Thank
injury.
you.
And so those are sometimes the hardest because they don't really have a complete ability to think things through all the way through, but yet they think that they know what they're doing. And so those are the cases that we probably need to cross the T's and dot the I's and make sure that they're fully educated each time you're going through a case.
And last, Jenny, anyone that didn't listen to your sage advice?
No, everyone listens to everything I say.
All right, there we go. Let's wrap it up.
Except your kids.
Seriously, everyone listens to Jenny. We were going to get to some of the appellate and appeals process, but we're going to do that in another show. So if there's any listeners out there that have questions or think they may be a good contributor to the podcast, please contact media@justicesteam.com. Thanks for listening, and to our special guest, thank you very much, Tracy. Thank you, Mike, for coming on. I'm your host, Brad Simon, and remember, folks, there's no sleep till justice.
Legal issue that I wish you saw. Your Honor, Mr. Know-It-All. Clear your eyes and I'll show you, 'cause with this writ I'll share. With this writ I'll share your lousy view. Yeah. With this writ I'll share your lousy view. Publish me up some new case law, young appellate justice gonna make a call. Falling all over myself to argue perfect points in public policy, 'cause with this writ I'll share your lousy view.
So it's just so I know
With this writ I'll share your lousy view. Yeah. With this writ I'll share your lousy view.
That's the key.
Bad loss in a justice hall. SoCal judge with a terrible call. Wave goodbye to Ma and Pa, 'cause with this writ I'll share. With this writ I'll share your lousy view. Yeah. With this writ I'll share your lousy view. Legal issue that I wish you saw. Your Honor, Mr. Know-It-All. Clear your eyes and I'll show you, 'cause with this writ I'll share. With this writ I'll share your lousy view.